For savings, investment and social groups, which we call chamas, the documents which would be able to moderate the relationship would depend on how it is set up. Where it is set up as an incorporated entity, in other words, an entity that does not have any registration, you can enter into rules. Now, these rules operate as a contract amongst the members, where people say, if so and so, if any member comes 5 minutes late, there's a 500 shilling fine. If any member is to make a contribution every month, this is the amount. If we're going to have an instance where a member wants to withdraw an amount, this is the rule that applies. Those need to be covered in rules, and there are rules that exist to cover unregistered clubs. Perhaps it would be advised for one to seek legal counsel before doing that. If the savings, investment and social group is set up as a partnership, the document to moderate that relationship would be a partnership deed. Obviously, don't use a generic document. It needs to be custom made to your needs, to be responsive to you, but the document would ultimately be a partnership deed. Finally, if it is registered as a company, we would recommend that the people who are registering would consider setting up a shareholder agreement, which, just as the case in the rules where it's not registered, or in the case of a partnership deed where it's registered as a partnership, a shareholder agreement would be what moderates the relationship amongst members of that savings and investment social group in their capacity as shareholders of the group.